it would say John Doe, trustee for so-and-so. So the legal title rests with John Doe. And you could even have the deed say John Doe without, in some cases, where there is no reference to the trust, and yet there could be an equitable or legal obligation regarding that trust. So you have this transfer of property from the grantor, that's the person who transfers it, to the trustee, and the trustee holds the property. It's legally in their name, yet equitable title, and you'll get comfortable with these phrases, I think, as I use them more and more. Equitable title rests in the third parties in this transaction, which are the beneficiaries. So at this stage, this is a pretty simple idea. It's where we'll call you the grantor, you could also be called the settlor, incidentally, where you transfer property to your friend John Doe, who you designate as a trustee. Now, often that will be done in some form of writing. There's case law, incidentally, where it didn't have to be in writing, but let's assume you're doing things properly here. You don't want to be on the outer edges of establishing new case law, when it's your assets and your fortune and your future that's on the line. So you have this document where all these rules are spelled out. And this person accepts this responsibility. They accept this property and agree to be a trustee. So at that point, the title rests in that person. But that's the legal title versus the equitable title. And the equitable, as that name sort of implies, means the benefits of the property. So when you think of equity, you think of fairness. Well, and another phrase or another sense in which that's used legally is to refer to the benefits associated with ownership of property. So equitable title would rest with these beneficiaries, whoever that is. So far simple enough. Grantor, trustee, beneficiaries. One other thing I'll explain to make it a little clearer about this separation of title. Before you did that, incidentally, when you own things right now, virtually all the property that you own, I'll assume are held by you legally and equitably, meaning those things are merged in you right now. Your car, assuming that's not owned by some finance company, but if whoever owns your house, for example, if it were owned free and clear, you'd have equitable title, meaning the right to use it, you'd have legal title. Normally, these types of title don't separate. They continue to travel together. It's only when you do something unusual, such as in the context of a trust, where they actually part ways, where legal ownership is separate from equitable ownership. And this is important for some of the principles we'll talk about later as we discuss trusts. So you've transferred the property, and you've transferred it to someone who's the trustee, and they're going to manage the property. They'll have all the rights to use or to operate and to utilize the property as they need to for its purpose, and its purpose is for the benefit of the beneficiaries. Now, the beneficiaries, incidentally, they could be your kids, they could be anybody in the world. Could be a charitable beneficiary. That's not uncommon. It could be your spouse. There are a variety of ways in which you can use trust to take care of people in which you want someone else to manage it. So really kind of what's going on here is that you've gotten the property out of your name. You don't own it any longer because you've transferred it into someone else's name who themselves don't have equitable title to it. They only have this raw legal status in which they can utilize it under the terms of this document, the terms of the relationship of the trust for the beneficiaries. So let me talk about who might be a trustee. Trustees can be, as I pointed out a while ago, you can be the trustee if you want. That again has a lot of problems with it. I don't encourage people to do it. Generally, when you create an irrevocable trust, you're doing it with the intention of creating a meaningful separation between you and this property. And whether it's relating to creditors, whether it's relating to the IRS, even predators, people who would try to get at your assets maybe fraudulently and in other ways. So often you do want this formal separation that an irrevocable trust provides. While you're technically still capable of having the status of trustee in this relationship, that sort of fiction gets shaky for reasons I've already mentioned. So I'm going to assume for the sake of discussion here that you're not going to choose to be trustee. Now there is incidentally a form of that in which it probably would pass muster in many states. It may pass IRS muster in some cases, meaning that for IRS purposes, this separate entity is taxed as opposed to you individually. So there are some cases where that can happen where you sort of become a co-trustee, or you have the power to remove a trustee under certain circumstances. You can imagine a variety of ways in which you might structure or configure your continued participation, but you have to be very careful. The more you reach out to retain control, dominion and control as it's termed in the law, the more that you reach out for that, the more shaky this entity becomes, or this transaction becomes rather, as an irrevocable trust. So one option would have been you, or you in conjunction with others. Another option is to use a institutional trustee. An institutional trustee is a bank. It could be corporations that focus on doing this exclusively. There are a variety of businesses or industries who make it their job to act as trustees. That can be, as you might imagine, a very lucrative position. It's somebody who they're entitled to be paid. In some states, there's a provision by statute based on a percentage of the amount of money that's in the trust. In some states, it's going to be based on a dollar amount. So usually these compensation plans are regulated to some extent by state law. But it is something that you want to consider. One of the advantages of having a corporate trustee is that they're perpetual. It's not vulnerable to the sort of problems you have with an individual. It's more a stable relationship. It's more of a predictable relationship. As you might imagine, institutions like that have rules that they have to follow. And these rules are, you can pretty much count on the institution being very conservative and being sure that it dots its I's and crosses its T's. You don't have that sort of thing with individuals. Sometimes, and this used to be more common than it is today, people would ask their lawyer to act as a trustee. A lot of lawyers are very uncomfortable with that. And I would suggest that you should be uncomfortable with that. In part because some of these issues exist with lawyers too. I mean, lawyers can have instability. They can die of a heart attack, and suddenly you're left with trying to replace your trustee. I think a lot is to be said for thinking about a corporate trustee, though often, as you might imagine, they're more expensive than if you had an individual. But there's sometimes it's worth it to pay a little more to have the certainty and the order that you want. But I'll go ahead and mention individuals. Anybody you can think of can be a trustee as long as they're competent legally and they accept the responsibility. It could be a family member. It could be a spouse. Again, that raises some red flags in some context. If your spouse has control, it's going to affect your creditor protection. It's going to affect your IRS implications. Is this separately taxed or not? Sometimes it can be friends, other professionals that you know, such as lawyers or accountants and others. So you have a lot of options in terms of choosing a trustee, but I would say this: whoever or whatever you choose, you should definitely have a successor trustee. And that kind of makes sense. In the event that something happens where your existing trustee cannot continue doing this, you want to have somebody else who can come in and kind of pick up the mantle and run forward. So in some cases, people will name 2 or 3 successor trustees, depending on the circumstances. So we've talked about the grantor, that's you. We've talked about the trustee. We know that the trustee wants to accept this responsibility and they have to be competent. We know you want to have your rules spelled out in your document that govern the operation of the trustee. And then let's also talk about then the other element in this sort of structure, and that would be a beneficiary. Beneficiaries can be anybody that you want to benefit. Often people name their children. It's not unusual to have their wife as a beneficiary. It could be their grandchildren, etc. There's no limit on your ability to name people or institutions as beneficiaries. Now, one distinction, though, in terms of layers exist among beneficiaries I think is important. You can have current beneficiaries, and you can have successor or subsequent beneficiaries. Successor beneficiaries are people that take upon the occurrence of some event. It could be even that when your child turns a certain age, that the money is or the income is transferred to a next generation. I mean, there's a variety of ways in which it may be important to trigger that transfer other than simply the death of your current or your existing trustees or beneficiaries. So there may be So there may be a variety of circumstances where not simply death would trigger that transfer from the current beneficiaries to the successor beneficiaries.